Greetings. Myself, Samsul Sameera, Assistant Professor, Crescent School of Law. On August 11, 2023, the central government has proposed a number of revisions to India's criminal laws. Mr. Amit Shah, the Union Home Minister, introduced 3 bills in the Lok Sabha. The Bharatiya Nyaya Sanhita Bill, BNS, which aimed to replace the Indian Penal Code, IPC, of 1860 was introduced. The Bharatiya Nagrik Suraksha Sanhita Bill, BNSS, sought to replace the 1973 Code of Criminal Procedure, CRPC, 1973. The Bharatiya Sakshya Bill, BSB, sought to replace the Indian Evidence Act of 1872. These measures were meticulously crafted following extensive talks with numerous views, including the Supreme Court, High Court, law universities, chief ministers, governors, and among all others. The central government's proposal of this new set of criminal laws aims to overhaul India's criminal justice delivery landscape. As a result, questions have been raised regarding whether the current laws have been misused to the point where they need to be changed. It also raises concern about the specifics of the modifications contained in the new bills. Now, we will outline in what way the new laws are different from their antiquated counterparts. In this process, we will touch upon the scope of the proposed new laws in reforming India's criminal justice system, which was in dire need of changes since the colonial era. First and foremost, we need to understand as to why there is apparent hasty transformation of India's criminal laws. So basically, crime, which is typically described as action or blunder or any illegal activity punishable by law, and criminal laws are inextricably linked in every community. The term criminal law refers to a broad variety of legislation. The primary purpose of executing any criminal legislation is to ensure that the party at guilt pays the consequences of their actions and that aggrieved party receives justice through well-established legal systems. These set of laws that deal with offences such as theft, murder, sexual assault, threat, and other illegal conduct is known as criminal law. It also provides the proper method for conducting trials of these convicted crimes. The rising crime rate and increasingly sophisticated nature of delinquencies as a result of digital aids demanded legislative amendments that might include strict and updated procedural and substantive measures to repress and prohibit such behavior. The underlying motivation for this vast revamp was the conclusion that the existing criminal laws were mostly vestiges of colonialism and needed considerable revisions. Previously, when we were the only ones who enforced the rules that were enacted by the British Parliament, but now they have up to 475 historical mentions in UK Parliament, London Gazette, Privy Council, and the British Crown. So this argument demonstrates why this long-awaited modification was required. Now let us analyze briefly on the history of India's criminal justice system. Criminal laws in India dates back to the Vedic period and the reign of Hindu and Muslim emperors. However, it was during the Britain's colonial rule in India that the movement towards systematization gained traction. As a result, the English legal system had a significant influence on the present criminal justice system. These reasonable and modern methods constitute a significant portion of the criminal statutes that are still in force today. They are similar to those manufactured during British control of the colonies. So many aspects of India's criminal justice precedes the country's independence from the British. Indian Penal Code, IPC, was implemented in 1860 and was designed after the English Criminal Code. The Code of Criminal Procedure, first enacted in 1861 and updated in 1973, defines guidelines for the criminal procedures. And the Indian Evidence Act, fashioned after English law, was passed in 1872. The Act has not changed significantly since it was proposed initially in 1872. In 1993, remarkably, the NN Vora Committee raised the problem of the political corruption. In 2000, a group led by Justice V.S. Malimath advocated changes to ensure that criminal offenders and their victims receive equitable treatment. By 2003, the Justice Malimath Group has released a report including 158 recommendations and suggestions. The Bharatiya Nagarika Suraksha Sanhita Bill, which will replace the CRPC presently, has 533 parts. A total of 160 sections of the existing law were amended, and 9 new sections were created and 9 sections were abolished. As such, in the case of the Bharatiya Nyaya Sanhita Bill, which would replace the Indian Penal Code, will have 356 sections instead of the previous 511 sections. So, with 175 sections amended, 8 new sections have been inserted and 22 sections have been removed. The Bharatiya Sakshya Bill, which would replace the Evidence Act, will now include 170 sections instead of the previous 167, with 23 sections modified and 1 section inserted and 5 removed. Now we will only focus on the Bharatiya Nagarika Suraksha Bill, that is the IPC, the one to replace IPC. So it is the primary statute governing criminal offences. It covers the offences relating to human body such as assault and murder, offences relating to property such as theft and extortion, offences relating to public order like unlawful assembly rioting, relating to public health such as the decency and the morality offences, defamation and offences against the state and whatnot. So several provisions of the IPC are retained in the bill, and changes that include the addition of organized crime, terrorist offences, increased punishment for certain existing offences, and the addition of community service as a punishment for small offences, petty offences were inserted. So certain IPC offences that have been struck down have been left out. So these include adultery, same-sex intercourse offences under section 377. So among the key modifications proposed in the bill are sedition is defined under IPC as bringing or attempt to bring hatred or contempt for the government or inciting disaffection against the government. It is punishable by imprisonment for a period ranging from 3 years to life as well as fine. So this offence is abolished by the bill. It instead penalizes the following, that is, exciting or attempting to excite secession, armed rebellion, or subversive activities, or encouraging the feelings of separatists' activities, or endangering the sovereignty or unity and integrity of India. So these offences may involve exchange of words or signs, or electronic communications or use of financial means. These offences may entail the interchange of words or signals, internet communications, or even use of money. These will be punishable by up to 7 years in prison or lifetime imprisonment as well as a fine. Secondly, terrorism is defined in the bill as any act intended to threaten the unity, integrity, and security of the country, as well as to intimidate the general public or disturb the public order. So terrorist attacks include using firearms, bombs, hazardous substances, biological or chemical it may be, to cause death, danger to life, or spread a fear of message, and also to destroy the property or disrupting the essential services. And further, the activity is listed in the second schedule of the Unlawful Prevention Act, UPA Act of 1967, such as unlawful aircraft, seizure or hostage taking. The penalties for attempting or perpetrating terrorism includes capital punishment or life imprisonment in circumstances where the offence resulted in death of any person, and incarceration terms ranging from 5 years to life in other cases. A fine of at least 5 lakh rupees will be imposed on the perpetrator. So the bill also punishes conspiring, organizing, or assisting in planning of any terrorist act with a 5-year to life sentence and a fine of at least 5 lakh rupees. So organized crime is defined in the bill as a continuing unlawful activity such as kidnapping, extortion, contract, land grabbing, financial scams, and cybercrime. All of these things are carried out through the violence, intimidation, or other unlawful means. Thirdly, the petty organized crimes. So according to this bill, the perpetrating of petty or organized crimes will be punishable from 1 to 7 years and a fine. So these crimes are performed by organized criminals, groups or gangs that produce general sentiment of insecurity among the populations. So pickpocketing, chain snatching and theft are some of the examples of organized crime. Thirdly, the petty organized crimes. So according to the bill, attempting or perpetrating petty organized crime is punishable of imprisonment from 1 to 7 years and a fine. So these crimes are those performed by organized criminal groups and gangs that produce general sentiments of insecurity among the population. Pickpocketing, snatching and theft are some of the examples of organized crime. Fourthly, murder. Murder committed by a group of people on the basis of caste or race. So this bill provides for a special sentence for murder committed by 5 or more people on specific grounds. These include race, caste, gender, place of birth, language, and religious beliefs. So each criminal will face a sentence of 7 years to life or to death. It will also result in fine. Finally, death penalty for gang rape of minor. The IPC allows for death sentence for gang rape of women under the age of 12. But the new bill provides for the death penalty for group rapes of women under the age of 18. Then, sexual intercourse by deception. The bill criminalizes the conduct of sexual intercourse with a woman, that is other than rape, through deception or a promise of marriage without intending to fulfill it. It will be penalized by simple or rigorous imprisonment for up to 10 years as well as with fine. Moving further, extending the applicability of certain offences relating to boys. So under IPC, importing girls under the age of 21 years for illicit intercourse with another person is an offence. The bill specifies that importing boys under the age of 18 years for illicit intercourse with another person will also be an offence. So these are the minor changes that have been brought by the new bills introduced to replace the Law of Crimes Indian Penal Code. In my next lecture series, we will see about the nuances of this bill and some of the changes that were brought to replace the CRPC and the Indian Evidence Act. Thank you.